SJC-11825, Commonwealth v. Joseph L. Roberts.
May it please the Court, Carolyn Burbine for the Commonwealth. This is the Commonwealth's appeal, and it's our position that the motion judge erred by denying the defendant's motion to withdraw his guilty plea based on the plea judge's failure to advise him that he could face the possibility of civil commitment as a sexually dangerous person. It's our position that this is not per se a reversible error, that the motion judge should have deemed the claim intentionally waived by the defendant, and that the motion judge erred by relying on Padilla versus Kentucky and by predicting on this record that the defendant would be a candidate for civil commitment. The judge did not advise the defendant of the possibility of civil commitment and being confined to the Mass Treatment Center for a term of 1 day to life, and that should have been done under Rule 12. But the failure to do so doesn't per se render an otherwise valid plea invalid. And
tell me, what is Rule 12? Where does this provision in Rule 12 come from? It doesn't have a statutory basis, does it?
No, I don't believe it does. I believe that, I think in Nolan it's explained as the way that our court tries to ensure that voluntary and intelligent pleas are actually possible by giving certain advisements to defendants.
Because there are lots of other collateral consequences that go along with felony convictions that aren't included in this.
Right.
But
right.
Are you saying this isn't quite how the judge decided it, but it's the argument that the defendant makes? You're saying that the judge could not, under Rule 30, say that justice has not been done in this case?
I don't think he could say that justice has not been done because I believe. Excuse me.
Because?
Because, well, first of all, his entire basis for granting the motion to withdraw the guilty plea is his, I'm trying to think of the word I want to make, his parallel, he's trying to make an analogy between Padilla and the requirement that the defendant get their advisement.
No, I know that. I'm just asking theoretically, could he have said, given the facts of this case and the crimes that were involved here, all sexual in nature, and all the other facts about Mr. Mancuso, et cetera, et cetera, et cetera, I do not think that I come to the conclusion that with the absence of any mention of SDP eligibility, justice was not done here.
I would say no, because you have to look at the colloquy as a whole. Our case law tells us this, the failure to give these advisements a collateral or a contingent consequence rather than a per se.
Right, but you say it's a factor.
It's a factor.
So maybe the judge relies on that factor?
Yes, the other factors would be that the defendant testified at a motion hearing and he made representations, obviously, during the colloquy. And our position is that the judge was not required to accept his version of events, nor did he in his ruling that counsel did not advise himself of the possible civil commitment. The judge just didn't address any of these ineffective claims. He just went by Padilla. And our position is that when you look at the colloquy with the judge, the defendant now claims that he was too afraid to tell the judge that he didn't understand what was going on, that he wasn't satisfied with his lawyer's service, yet he interrupted the proceedings 3 times to consult with his lawyer, which shows he did not fear the judge. And after the judge read the first indictment, he told her that he had a question, and she said, consult with your lawyer.
But where in the record is it plain that he understood that when he pled guilty to this sexual offense, he could be subject to being civilly committed from 1 day to life upon his release?
Well, he didn't get the advisement from the judge, but he claimed that his lawyer didn't advise him. There's no affidavit from counsel, and his claim is refuted.
Counsel's in jail.
But but not for what happened
Well,
here.
I understand, but I mean,
I understand, but he claims that he wasn't advised of anything by his counsel, but that's refuted by the counsel's signature on the waiver of rights form that he advises the defendant of all matters within Rule 12, including the consequences of his guilty plea, and that at least calls the defendant's credibility into question. I'd also point out he didn't raise this in his first motion for new trial, and he explains that away as, well, I told my lawyer, Attorney Corman, and he refused to do it, and he said he would quit if I didn't drop it. He told me I could do it myself.
So you're basically questioning what the motion judge did in terms of weighing all these factors.
Yes.
You're basically saying that the judge weighed them incorrectly?
I'm saying he didn't weigh anything at all.
Weigh them?
I'm saying that he didn't do anything at all except jump to Padilla and say, well,
Yeah,
this
but
is
you're
like...
listing all these things that he should have taken into account.
Yes.
And maybe he did, including the fact that the attorney that you say should have put something in was, for whatever reason, unavailable. He was incarcerated at the time of the evidentiary hearing.
But he doesn't put that at all in his ruling. He doesn't make any ruling on ineffectiveness of appellate counsel or...
He doesn't have to make findings of fact, does he?
Well, it's just it's not in his analysis either. He doesn't say, I found counsel ineffective. That was one of the claims. He just jumps to, if you don't get the advisement, and I rule that that advisement is a per se necessity, then it's not an acceptable plea.
Right,
and I disagree with that, where all of our case law says that's a contingent.
But the question I was asking was, okay, but theoretically, hypothetically, could a judge say on these facts, justice not done, therefore new trial because I don't think there's any dispute. The judge didn't advise, the plea judge didn't advise him of the one day to life real possibility here.
But as it stands, that's not a per se requirement. That's
Well,
my
I'm
point.
asking you theoretically, what would be the case? If a judge had gone through the hoops and said, I've weighed everything, I think this collateral consequence is such that in this case, justice wasn't done under Rule 30, he gets a new trial. Are you suggesting that a judge could not reach that result? Because it is a contingent?
Yeah.
That's where I'm trying to understand your argument.
Yes, he has to. First of all, I would say he didn't properly weigh it. He didn't consider anything except his interpretation of Padilla. I suppose if he had said, I credit the defendant's version of events, that he wasn't advised, that he had no... But even then, I just think that would be error on the judge's part, because...
Well, it's fair to say the judge did not make any findings as to whether the defendant would have pled guilty had he been so advised.
Correct. And Padilla does say that even if you find with an ineffective claim that counsel...
Second prong.
Right, second prong has to be met. And we absolutely have nothing by the judge here
But this
stating that.
this is not an ineffective assistance of counsel ruling by the judge. He's ruling on voluntariness, right?
Right, voluntary, knowing, and
So,
intelligent.
he didn't really have to go to that second prong.
I disagree because I think it's clear from his ruling that he just jumped to Padilla, that he didn't do the required analysis, that he didn't...
Okay, I understand that, but the judge is saying that I don't think that this plea was voluntary, given all of the circumstances in this case.
But I believe that actually what he's saying is I don't believe it was voluntary because he didn't get the advisement. I think he just cut off his analysis right there, and that's not sufficient. That he should have at least addressed more than that. I mean, when you have a contingent consequence...
Not just what? I mean, the
should have looked at, was he represented...
Well, it doesn't matter. Contingent collateral doesn't matter in the context of voluntariness. That's a factor that's been considered in the ineffective assistance of counsel rubric, right?
But in terms of voluntariness, the defendant averred at the colloquy that he had been satisfied with the representation by counsel, that he'd had enough time to fully consult with his lawyer.
So that's dispositive by your argument?
I think that should have been considered by the judge, and he didn't consider any of that. He just jumped to Padilla, and I think that should have been taken into account. that you can't just discard what they said at the plea colloquy because the defendant makes different claims later on. That has to carry some weight.
But are you contesting the fact that he was never advised?
No, I'm not contesting the fact he was
well,
not
you
received
are.
it, and he was
You're contesting the fact that he was never advised by the
by
lawyer.
the judge.
Yes, by the
the
lawyer.
judge.
You are contesting, it seems
Yes.
to me.
Yes, I'm saying that the record
the
doesn't
judge is
clearly show.
basically saying, notwithstanding the straightforwardness of the approved comment, and that's in connection with Rule 12, and acknowledging that this defendant was never advised of the possible consequences he could face pursuant to 123A. The Commonwealth argues that the deficiency is not fatal. You're not now contending that there was no such deficiency.
By the attorney or the judge? I'm sorry.
Well, this just says he was just never advised.
I read it as he was not advised by the judge.
Well, that's not what
the
it says.
judge,
It said this defendant was never advised of the possible, maybe that does mean by the judge.
yes,
but-
I believe in context it means just by the judge. He didn't address any of the ineffective claims or Mancuso's.
So if we were to say that Rule 12C3B creates a requirement, much like the alien warning requirement of Chapter 278, Section 29D, if we were to say that Rule 12C3B creates a requirement that SDP warning be given, and the failure to give that warning requires a judge to vacate a guilty plea, what do you say about that?
Then I would have nothing to stand on. I don't think it's warranted here. It's our position that it's speculative that he would ever be subject to an SDP hearing. There's an entire complicated process that has to happen. The district attorney has to petition.
You think on these charges it's speculative that he would be subject to that the district attorney, it's speculative this district attorney would seek it?
But even if we did seek it, there's a whole process. You have to
I understand
have
that,
the probable cause, the qualified examiners. It's not a given like in Padilla. The concern in Padilla was that the deportation was certain. It was mandatory. There was no question that deportation was going to happen to this person.
But
Here,
even
you don't have a mandatory civil commitment. It's
No,
not inevitable.
but even before Padilla, Chapter 278, Section 29D required a judge to give the alien warning. And there's no guarantee that anybody would have ever been deported even in those circumstances.
Correct. But I'm not saying that the judge wasn't required here to give the warning. She was. And I think that's the rule says that. And I'm not disputing that. But what I'm saying is it's still a continuing or collateral consequence, as a result, the lack of that warning, especially where it's not a given that every single person who's has committed a rape or an indecent A and B is going to be subject to civil commitment proceedings, that would be necessary, or that here, it's at all established that sort of analysis is necessary. It's not a given that he would be found SDP or that any other defendant would be found SDP, and so I don't feel that would be necessary. And I also don't feel that it's been established here. It's not an imminent danger for this, in general. And I would point to Steele versus Murphy that the charges might make him, in that case the court said, well, the charges might make someone a candidate to be classified as SDP, but classification is not a direct, immediate, or largely automatic result of a guilty plea. And that is why we would consider it contingent, and we would look at, well, what about the whole plea? Was it voluntary, intelligent, et cetera, even given the lack of this
I'm trying to understand your position. Now, let's assume the facts were clear, that he did not, when he pled guilty, he did not understand that he was facing the risk of an SDP upon being found guilty.
Right.
Would the judge have abused his discretion in ordering a new trial?
The judge didn't do the analysis as to whether he would have pled guilty had he known of the civil commitment risk. He did not do that analysis.
Okay, so you're saying there must be an ineffective assistance of counsel analysis, even though the judge did not base his ruling?
I'm saying that what you would have to have is a ruling by the judge that, but for the lack of this, that even if the defendant had been given the advisement, he still would not have opted to plead guilty. I point out, which I haven't done and I should have, that he was facing very serious charges that could have led to multiple life sentences. Had he gotten that advisement, would he still not have pled guilty? I think that's a very real question.
So you're saying
Wouldn't that be implicit, though, in, excuse me, I just wanted to interrupt you for a minute. Wouldn't that be implicit in a finding of not voluntary?
Well,
that he wouldn't have done it otherwise?
Except that he did not address that. He just jumped
I know,
to Padilla. I'm sorry. It's just
that's what
not,
implicit means, that he
I
didn't
know,
address
but
it.
I don't believe so. Not the way that the judge wrote the decision and the way he analyzed civil commitment is a mandatory result here, which, as I've stated, we disagree with. And I think you would have to have some kind of finding by the judge that, and it wasn't, that the defendant indeed would not have done what he had done had he known of the civil commitment. I think that's key here, and that was important in Padilla. In Padilla, they actually remanded back for that determination to be made. They said in the ineffective claim, it wasn't enough just to show prong one. You also had to show prong two, and that type of analysis has not been done here. So I would argue that it's not sufficient at this point.
All right, thank you.
Thank you.
Good morning.
Counsel, why shouldn't we consider waiver here? I mean, think of the prejudice to the Commonwealth. This individual pled guilty to essentially 9 counts of raping children back in 2005. We're now 2015. He wants to withdraw his plea. How are we going to have a trial? I mean, why should this was not raised for years? He knew he didn't get this advisement. He filed motions for a new trial, not raising this issue. Why should we even consider it?
He actually raised this issue repeatedly. From 2 days after the change of plea, he was writing to everyone. The reason I was appointed Justice Cordy.
Oh, in 2007, he filed a motion for a new trial. Is that right?
That's true. That was by Attorney Corman.
Right.
And there is in the record before Judge Veery and Judge Connolly, who heard the evidence. There is evidence that Mr. Corman and the defendant were at odds. The fact of the matter is this case was screened on yet another request and was turned down. Counsel was appointed because of the voluminous nature of Mr. Roberts' filings. You're talking inches. And this is a case, may I submit, that the trial, that the Superior Court judges would understand that the mental illness and the delivery of the message occluded the content. And it took digging to understand exactly what was going on. But there's no intentional waiver here. What happened was immediately there was a hue and cry, letters to the judge, letters to the governor, letters to senators, letters to everyone in the world. This is all in the record.
Letters about what?
About what had happened. Letters to
that I pled guilty to things I didn't do?
He says that he did indeed intend to present a defense. This whole allegation came up in the context of a divorce. There is nothing in this record that shows that Mr. Mancuso...
So you're saying he wants a new trial, actually wants a trial?
That's
it's subjected potential life in prison. He certainly isn't going to be able to get what, he obviously got the benefit of acknowledging his guilt, of not putting victims through the additional trauma of a trial, so he's prepared to face life imprisonment. That's what you're saying.
Decision. That's his decision. I mean, living with these kinds of convictions is obviously life-altering. At one point, he did withdraw the motion. It was allowed without prejudice. I mean, mental illness is a very serious issue here.
So his issue is, I didn't do this, and I was misled into pleading guilty? Because I didn't know there would be other consequences maybe down the road? Maybe there would be a civil proceeding?
Did not know that. Mm-hmm. The fact of the matter is, and this is before the judge, I mean, the issue before this court, I know you're focused on waiver, and I'm addressing a waiver because I think there was...
I'm just looking at the enormous prejudice to the Commonwealth.
But in this instance, there was clearly no waiver at any point by Mr. Roberts. There's also an enormous amount of evidence about ineffective assistance of counsel And that evidence is corroborated by the docket in the case, which shows counsel not showing up, no motions being filed, etc. There is also BBO finding and reprimand that Mr. Mancuso was not available. In other words, I would like to get back to the fact that the judge had discretion with respect to two things here. One was whether or not Mr. Roberts should be deemed to have waived the issue. That itself is a discretionary call, and there's nothing in the record that suggests that that call, in light of the history of mental illness, the substantial evidence of ineffective assistance of counsel, that that was arbitrary or capricious or abusive in any way.
But if he raised the issue before, in an earlier motion to suppress evidence, and you're claiming there was no waiver, that motion was resolved against him, isn't that the end of the story?
Motion for new trial.
There was a motion for new trial that raised only the issue of competence.
Oh.
In other
He
words,
raised
Mr.
it with the
Corman-
lawyer, but the lawyer, at least the record would say, that he raised it with Mr. Corman, but Mr. Corman refused to put it in the motion. So it didn't.
And it may well be that Mr. Corman didn't really focus on it because of the mental health issues. I mean, and I have also spoken to screening counsel, and the thing that really presented to them was the issue of competence. Taking all of this together, Mr. Mancuso's clear dereliction of duties, the clear absence of any participant in that hearing whatsoever making any reference to the clearly discernible, and that's the phrase that Judge Veary used, the clearly discernible risk of very grave consequences, it's very hard for this court to do what it must do in order to overturn it, which is to find that the judge acted arbitrarily, frivolously, or contrary to law.
Except I don't mean except, but the judge's decision, I mean, you argue justice has not been, that is not the way the judge decided it. He said no compliance with Rule 12CB, whatever, 3, ergo, I mean, it's sort of, that's the end of this story. And then he adds the Padilla part about discernible consequences. But I guess my question is, A, he didn't really look at it in the way you're suggesting, but B, more to the point, even without an ineffective assistance of counsel lens, looking through that lens, wouldn't it be important, if you're going to find no justice has been done, that you consider, if you're the judge, whether the question whether the defendant would have pled, given what was being offered, even though this was a contingent consequence? Now, the answer may well be no, but at least to have considered it, wouldn't that be important?
I think that's a conflation of the second prong of Safarian with the voluntariness, because I think the voluntariness asks not would the defendant have pled anyway, but asks instead, was the defendant apprised of the important consequences,
but it's
the relevant consequences?
But it's a collateral consequence. Why should this consequence be thrown into the equation of voluntariness if it's a collateral consequence?
The reason is that, first of all, the notion of collateral is one that I think has fallen by the wayside. Second of all, it's because
it's fallen by the wayside in terms of ineffective assistance of counsel, but has it fallen by the wayside for purposes of the voluntariness analysis?
I think it should. I don't think that it is conceptually all that different. I don't know that it should survive in one context and not the other. It doesn't seem to make sense that it would do that. But getting to the question, why, to your original question, Justice Spina, which is why should we not look at whether or not he would have pled, somehow conflate those in this circumstance that you're calling collateral. The cases, we have one case that's dead set against us, that's the Morrow case. That case, you could say, was abrogated by the rule. The rule was adopted 6 years after Morrow came down and made it clear that this is a requirement in relevant cases. Now, what makes a case relevant? That has changed over time. But relevant is a defendant who presents with mental illness, significant mental illness. We have that. And originally, where the defendant was pleading to a predicate offense. Now, since 2004, it's whether there's a predicate offense anywhere in the background. In all of those circumstances, the reporter's notes say that's a circumstance where we're essentially presuming it would be relevant and it would be significant for the plea, just in the way the maximum and minimum penalties are relevant to the plea.
But doesn't that go to the analysis of whether or not the defendant would have pleaded guilty? Isn't it relevant to that analysis, that question?
It's a different frame, but it really has a large overlap, and maybe in fact it's entirely intersecting, because if it's a relevant circumstance to the plea, if it makes the plea, if it's relevant to voluntariness, then yes, I guess you'd say in another frame, it means he wouldn't have otherwise done it. But that doesn't mean you can't get at it circumstantially. Here there was direct evidence. Mr. Roberts said that had he known.
But there was no analysis by the judge.
Pardon?
There was no analysis by the judge.
This court has frequently said there doesn't need to be. Instead, you look at the record and you see whether or not there were facts in the record. The judge does not need to make findings. There were plenty of facts in the record before this judge. This judge had a transcript. The Commonwealth had the opportunity to put in contrary evidence. There was no evidence whatsoever that Mr. Roberts would have pleaded guilty. Bear in mind, let's look at the facts.
Did he file an affidavit saying that he would not have pleaded guilty had he known?
He not only did that, he testified to it.
Okay.
He testified at the hearing. In this circumstance, bear in mind, this is a straight-up plea. There's no agreement. There's nothing that would allow this bench to say, well, he got the benefit of his bargain, he had a bargain. There was a tremendous giving of consideration and value for the plea by the Commonwealth. There was nothing. He pled straight up to every charge, and there was no deal on the sentence. The sentence was the guideline sentence. He got no consideration for the plea.
Well, he didn't. I mean, I don't remember whether part of the plea was, I think it was, Judge Del Vecchio, that she wouldn't exceed the prosecutor's recommendation, correct?
Wouldn't exceed the prosecutor's recommendation.
And the prosecutor, as I recall, did not recommend life sentence.
10 to 20.
It's not a life sentence.
Right, but I don't think that was the guideline. I'm saying that
the statute allowed life sentences, right?
I'm sorry?
I'm just saying there was some consideration here. That's all I'm saying. I mean,
not a negotiated consideration. The Commonwealth came in with their recommendation, which was in excess of the guidelines. The judge gave a guideline sentence. I don't think that every sentence that's below the maximum means there was consideration, because the judge wasn't likely to give the maximum. I'm saying there's no, in many of the cases which say Davis these are appeals court cases, Federico, Davis, Rodriguez, there are cases that say it's required, but not in every case are we going to undo the plea. And they'll look at circumstances, objective circumstances, that show that it really didn't matter to a hill of beans, that either the defendant was not eligible, that there was no indication he would be eligible, or the defendant had received straight probation. If you look at the facts of the cases, there are clear objective indicia that it wouldn't have amounted to any kind of difference. It's hard to imagine how it wouldn't matter here. In what sense is it a requirement if this doesn't undo it? He got nothing for it. There's no plea agreement. He has no advisement by either the judge or his lawyer or the prosecutor at any point in that hearing. There's no assurance whatsoever that he knows, and in fact, the judge has evidence that he doesn't know.
How do we know that the lawyer didn't advise him?
Well, we have the defendant's testimony plus the mother's testimony. The mother was present throughout the entire prior day, February 1st, 2005, when they're all assembled in the lobby of the Brockton Superior Court while Mr. Mancuso is frantically trying to try another rape case. And the family is sitting outside the entire day, never get before the judge. Mancuso comes out. This is the testimony, and it's very clearly corroborated by the mother's submission years ago to the BBO, letters in the file, etc., that Mancuso said he couldn't possibly do this. trial, that the judge was not going to allow another continuance whatsoever. They had retained Mr. Mancuso. They had no ability to get another lawyer. The mother said, I never heard a thing. He never spoke to him privately. We know there were only 2 meetings between counsel and Mr. Mancuso. One, when he was in lockup at the jail before he met bail. It was introductory, and then a meeting at the Hilltop 1 month prior to the hearing, and that was lunch. That was it. So the judge had facts before him which supported his implicit finding, support his ruling, the implicit ruling that this was not voluntary, and that's all. We do not need the kind of fulsome record. I mean, defendants are usually in the position of the other side of this coin.
So craft the rule that would emerge from this case if you had your druthers. I assume you're not asking us for a per se rule, that the failure in every instance to give that instruction requires there to be a new trial. Is that correct?
That's correct. I believe that, in fact, the rule sets it out properly. Rule 12C3B requires that the ruling be given in a relevant case. And that means that wherever the defendant's record or the instant charges that are then before the court in the change of plea hearing are eligible offenses, predicate offenses, and where, in any instance like that, I don't think you even need to go to the mental health issue, but if there are predicate offenses, then the warning must be given.
Okay, and if it is not, is it your view that it's a new trial in every case?
Yes. I think that there should be, unless there are clear circumstances that show that it was nonetheless. It's like a presumptively involuntary. I think that the Commonwealth could, in the appropriate case, show that it was nonetheless voluntary for the reasons I've given already.
Presumably
like
the
a plea
Commonwealth said,
agreement.
we're not going to move. We're not moving for an SDP commitment. So what's the harm?
They could have done that in this case.
No, I'm
Judge
just
Cor-
saying that would
Justice
be
Cordy.
another.
They could have done that.
do
They could have said, we'll do the evaluation right now, and we'll let you know. They did not. So, yes.
Could they
that
do
would
it
be
now?
a perfect example where the presumption could be overcome. Thank you very much.
Thank you, counsel.